The H1B Guy here, and today, the H1B Guy news for the week ending September 18th, 2020. But before we get started, I'd like to ask you, if you haven't already, to please subscribe to the H1B Guy channel here on YouTube. It helps me to produce more content like this for you. I also wanted to mention that the H1B Guy offers one-on-one consulting services. If I can help you with any document or evidence review, any audit or case compliance review, please reach out to me. I'd love to hear how I can help you. I also wanted to mention a very happy birthday to my partner in crime. Thank you for everything that you do for me and for our family. Love you. Now, the news. September 12th, 2020. On a post for Axiom published by Steph W. Kight titled, 1 million waiting for employment-based green cards. Quote, around 1.2 million people are waiting in line for employment-based green cards, including workers, their spouses, and kids, according to analysis by Migration Policy Institute's Julia Galat. By the numbers, caps on the number of green cards that can be given to any one country means 68% of the backlog are people from India and 14% are from China. Approved applicants awaiting visa availability as of April 20th, 2020, not including spouses or children. India, 398,132. China, 72,593. El Salvador, 21,336. Guatemala, 18,718. Honduras, 14,471. And the rest of the world, 67,072. I've discussed the green card backlog and S-386, the Senate bill intended to eliminate said backlog over a 10-year period, a lot over the last couple of months. Here's some real, tangible data on what the current backlog actually looks like. Total applicants are 592,322 individuals, and that number does not include spouses or dependents. The article estimates the current backlog would be somewhere in 1.2 million. I don't think that's an overestimation. Let's just say there's 300 spouses and 300 dependents, right? Which are children. So that's another 600,000 to the 592,322 number. So puts it right at 1.2 million. If S-386 isn't the answer to solving this atrocious problem, then looking forward, we have to ask, what is the solution? Can a new system based on merit that gives heavy weight to time spent working in the U.S. be implemented and address this issue? September 14th, 2020. An article written by Sophie Quinton for Pew Research titled Coronavirus, Trump Chill International Enrollment at U.S. Colleges. Quote, administrators at Michigan State and other public colleges and universities nationwide say they expect fewer new international students to enroll this fall because of visa delays and safety fears. Enrolling fewer international students who pay a premium, Michigan State charges international students over $41,000 a year in tuition, almost triple what local students pay, will be another financial blow. When pressed, we've estimated a 25 to 30% enrollment decline, but I hesitate to put a number on it, said Brad Farnsworth, Vice President of Global Engagement at the American Council on Education, a Washington, D.C. based higher education membership organization. Last year, more than 1 million students studied or were engaged in postgraduate training here, according to the Institute of International Education, a New York-based nonprofit. That's about 5.5% of all students at U.S. colleges and universities. About half of international students come from China and India. Dennis Dunham, Executive Director of the Office of Global Affairs at the University of Central Oklahoma in Edmond, Oklahoma, said, I do think it will recover because America's education system is still considered one of the best, if not the best, in the world. You can literally translate that into millions of dollars, Dunham said. Full-time international graduates at Central Oklahoma pay over $15,000 in tuition a year, not including activity and course fees, while in-state students pay about $6,000. I've discussed the F1 OPT pipeline that's created by international students, particularly those from India and China. Here, we see the ramifications of a global pandemic, the travel ban, and the current policies on immigration from President Trump's administration. I've talked a lot about the gravy train that international students create for U.S. institutions of higher learning. It's all about the money. International student enrollment being down an estimated 25 to 30% will create breaks in the circle and the cycle that we talk about a lot here on this channel. Fewer graduates over the next 18 to 24 months means less human capital being available for open jobs. While some may view this as a good thing, stating that more jobs would be available for U.S. workers, others will say we're missing out on the world's best and brightest that would come to the U.S. to study at some of the best institutions in the world. It's going to be very interesting to see how all of this plays out over the next year and a half or so. September 15th, 2020. In an article written by Nick Kolakowski for DICE titled H1B Revamp Could Radically Reduce Visa Users. Quote, although the specifics are under wraps, that didn't stop Fragaman, a law firm specializing in immigration law, from hypothesizing in a blog post about the changes' potential impact on the H-1B. This could lead to the requirement that H-1B employers and end clients jointly obtain labor condition applications, LCAs, for H-1B workers at client sites. A joint LCA requirement would create de facto joint employer liability for compliance with obligations concerning H-1B wages and working conditions. The regulation could also address other aspects of H-1B wage requirements. The proposed DHS revamp suggests that Trump's executive order temporarily banning H-1Bs won't become permanent, although that situation could always change. Over the past few years, various tweaks to H-1B policy, including a substantial adjustment to fees, has led to a rising rate of application and renewal denials. Changing the definition of specialty occupation, however, could end up having an even larger impact on how tech firms utilize the visa. I've covered Nick's articles from DICE a good bit, and I will continue to do so. DICE is one of the primary sources for IT recruiters and IT candidates. It's had its ebbs and flows over the years, but DICE is still one of the industry standards. What struck me from this article is that he references Fragaman. Fragaman is an extremely large and very powerful immigration law firm. Fragment speculates in a post from September 4th what the reform to the employer-employee relationship requirements would actually be, speculating that the end client would also need to obtain a joint LCA along with the H-1B employer. First of all, no large corporate enterprise is ever going to do that. An LCA is the end all when it comes to being legally obligated to paying a prevailing wage. No enterprise organization is going to risk that obligation for a contract based consultant. Ever. This would literally put an end to 90% of the third party vendors out there. The actual death of the third party consultant, as we've been predicting. I'd also expect something like this to be challenged in the courts almost immediately. I'll continue to monitor this situation very closely. All signs are pointing to a big announcement sometime in the next 2 weeks leading up to the first presidential debate. Will we see it? That's still to be determined. For the full post, check out the H1BGuy.com. If you haven't already, please like this video and subscribe to the H1B Guy channel here on YouTube. Click the all button so you receive notifications for when posts go up. I want to thank you if you've made it this far for watching. I just really appreciate your support and taking the time to watch my content. The H1B Guy, your global source for all things H1B.